Hi, my name is Kirk. I'm a personal injury and accident attorney in Baltimore, Maryland. I wanted to take a few minutes today to talk about the value of a claim and specifically the role of medical expenses in assessing and assigning an appropriate dollar value for a case. Medical expenses come in two forms. One is past medical expenses, that is, medical expenses that have been incurred for the accident, for the injuries sustained in the accident to date. And the second category is future medical expenses, those which are reasonably likely to be incurred in the future. The assessment of medical expenses is to some extent a mathematical exercise, simply tabulating the amount of the bills and submitting them as part of the claim, but the process can become substantially more complex. Insurance companies often raise two arguments as to why the full amount of medical expense should not be included in one's claim. They initially argue that the charges for medical services are simply not related to any accident or any injury sustained in the accident. The second argument is somewhat more sophisticated. Insurance companies will frequently argue that the charges are simply excessive, that they're not in accord with reasonable, customary, and usual charges from medical providers for those same services in the geographic location of your loss. A skilled attorney can help you defeat those arguments and make sure that you receive the full amount of your medical expense as compensation for your loss. Maryland law does not recognize a direct set-off for medical expenses paid for by third parties, so that the amount of your settlement, judgment, or verdict would not be directly affected by the amount of medical expenses paid by a third party, for example, an insurance company. However, Maryland law does recognize that that third-party payer has the right to assert a lien on your recovery. Here again, a skilled attorney can negotiate that lien for you, get it reduced to the lowest possible amount allowed under the law, thereby ensuring that you get the highest possible amount in your pocket. When it comes to future medical expenses, here again, the law can be complex. Typically, one is entitled to recover for future medical expenses only where an expert or a physician testifies that it is reasonably probable that specific medical expenses will be incurred in the future.